Hello, beautiful humans, and welcome to Defense Diaries. I am your host, Bob Mata. And as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So were you guys getting a little anxious there with our late start? Little 7 minutes late?
Tell them what date it is and what this is our continuing coverage of.
Yes, ma'am. Today is October, I believe the 7th, or is it the 8th?
It's the 7th.
It is the 7th, October 7th. And this is our continuing coverage of both Delphi and the Alison Davis case, both of which our dear friend of the show, my brother, who was supposed to be up here for a show with his wife this summer, and it slipped by us, which is super predictable. Andrew Baldwin was a part of both of those cases. We're going to bring him straight away on. Why waste any time? Why leave him in the back?
You know him. You love him.
Hey, what is up, my friend?
Hi, Bob. Hi, Allie.
How are you?
I was talking to Allie off screen about her. She actually practices law still, so unlike you. So we're going through some of the war stories.
Fair enough.
Bob. Yeah.
Fair enough. And, so look, we've got a couple of things on the plate tonight. We're definitely going to talk about Delphi. We're going to talk about Richard Allen's case. And then we're also going to talk about, and I don't know if folks were aware or haven't watched, and if you haven't, you should go back. We had covered your trial that you had after Richard Allen in front of none other than Francis Gull.
Yep.
And you had a very different result in that case, and that was another homicide case, and you prevailed on that. You had your partner, trial partner there, and one of your is he a partner in the firm, or is he an associate at this point?
He's been a partner a few years now. Max Wiley.
Max Wiley, who I've sent an invite to, and Max may be joining us later, we hope.
Mm-hmm.
But that case was another hard fought, a lot of specious decisions by Judge Gull. However, you prevailed, and you were
got it
able
right
to get that jury to come back with the correct verdict for your client. So we're going to get into that in the second half here.
Yeah, we'll be talking about that because CBS 48 Hours, the national news magazine, was there covering that, and so that's one of the reasons I wanted to.
Yeah, Andy, I saw your and I'm going to give a shout out to your Twitter page. It seems like you finally got off your ass and hired somebody to handle a Twitter account for your law firm.
I tried to tag him on Twitter and I couldn't find it. I looked for
it's not under Andy, it's under the law firm's name. So hold on.
Well, this is news to me. Breaking news. We have a Twitter account.
You do. And hold on, I want to find.
While you're looking for that, I'll say hi to Stephanie from Montreal. Thank you. And thank Idiot Wind for gifting 20 Defense Diary podcast members.
Oh, we love when you start out like that, y'all. We love it.
Yes,
we love it so much. All right, Andy, what is the name of the firm? Is it the People's Law Firm? Like the criminal law firm?
The criminal defense team of Baldwin, Perry, and Wiley.
And that is exactly what I'm going to give your handle out so I can up the followers that you guys have.
Oh, that's very nice.
Yes.
Whatever that means.
They can't find you by your name because I tried today.
The criminal defense team. Yeah. I got that. I don't know, almost 20 years ago. It's just crazy that I was able to get criminaldefenseteam.com, which is our website name.
That is great.
Pretty good.
For like $200. And I didn't even know what I was doing. Somehow you
just went on GoDaddy and typed it in, and you're like, boom, nailed it. Yeah.
No one's been trying to buy that from you since? No one's come at you?
No. I mean, there's a price for everything. So.
Right.
All right. So I found it. So mods, would you be kind enough to throw this in the link? It is Andy's firm's Twitter handle or X handle, and it's at crim _def DEF _team. Now, one of the reasons, other than wanting to get you some more followers on that fabulous Twitter handle you guys have there, is that I saw this picture of Andy and Max getting their makeup put on before they did their 48-hour interview. Yeah. So I'm sure you're going to look fabulous in the episode. I'm excited about it.
Yeah.
Is it really kind of the way I describe that case? It's kind of like the staircase, the Michael Peterson case, except in reverse, where Alison Davis was, she was obviously the one charged, as her husband was the one who had met his demise. And of course,
Yeah.
the state thought that she was responsible for his death. So it's a fascinating case, and it's going to be interesting. But we'll get to that. We'll talk all about that case.
Yeah, and we're talking about that, remind me that I was at the NACDL national conference every year in the summer and ran into the attorney for the original staircase that was.
You did?
Yeah, and yeah, it was a very good conversation. But we'll talk.
Just remember, the owl did it. The owl. It was the owl.
I mean, it's
frankly, it's not a ridiculous theory, to be honest with you. It's like it's got some legs.
All right to me.
It's kind of like my coyote theory of the John O'Keefe death, slip and fall, coyote predation, like a little bit, couldn't move him and dipped off, and then that's how you. So I threw just, this is unknown. I threw, which was so poo-pooed by so many, I threw my theory at David Yannetti when we were at the event there in your neck of the woods last Wednesday. He was a fan. I'm just gonna leave it at that. He was a fan. He was like, my theory of that case is a little bit different. So, all right, Andy, before I start kind of grilling you, and Allie does too, kind of give us a summary of what's going on with Richard Allen right now.
Richard Allen himself?
Yeah, I mean, the case, if you've heard anything about Rick, people always like updates. So
Rick's always trying to call me, and my phone's always on mute because I'm in court a lot, and I just don't like, that's pretty embarrassing. That actually happened during a hearing in the Delphi case, but that's another story. But
I remember that. I was there for that.
Yeah.
One time my phone just started, I had everything off, but I hit like a read button and it started reading like my texts and out loud. And I couldn't stop it. And I'm like pressing things. It was horrible.
But you were in front of Gull.
Yeah. It's
anyway, Andy kind of looking around like it wasn't his shit, and he's like, like kind of stink eye and everybody else in the courtroom.
Well, I didn't actually. My thought process, Bob, was I was like, I don't know whose that is, but they're in big trouble. Oh my god! And then eventually, I'm like, oh, that's mine.
That's mine.
But that's a horrible. So Rick has been trying to reach out, and I haven't really talked to him for a while, but last time I talked to him, he's always trying to make, when you do talk to him, he's more interested in you than, it's almost like he's tired of us asking about how he is. And so it was pretty amazing. Last time I talked to him, he's like, how's Michelle? That's my wife.
Yeah. He
said her by name. And how's Kinsey doing? One of the interns that works with me. And, and how's things going? And he's just very, that's just how he is. And I think part of it, he just doesn't want us to feel bad for him. But by all accounts, I think he's doing okay. I was very skeptical about the Oklahoma move.
Yeah.
But it seems like it's a good thing. But Rick probably is not going to be telling us really how he's really feeling.
News.
Right.
But so hopefully he's doing as well. He just needs to survive, hopefully, until the opinion comes out that reverses. And it's awkward for me to talk about the court of what's going on right now in a way, because we, as you two definitively know, because you're trial lawyers, we are the most. I don't know what the right word is. We are very. What's the word? Where you. I'm worried about everything, just like anything that and also that if you say something, the opposite is going to happen, and just stuff like that.
Oh,
right.
I can't think of the word, but so it's and on top
Are you
of
saying, well, a little bit superstitious.
That's I can't think of the word. So I'm a little bit, or a lot. We trial lawyers are, generally speaking, very superstitious people, and even though I am confident that this ultimately, once the Court of Appeals looks at it, they will do the right thing, in what my opinion is of the right thing, and reverse this. but you also don't want to say that because they could be getting, there's 15 in Indiana, there's 15 Court of Appeals judges, and 3 of those judges will get this case. That if people don't know that. And so then Stacey Uliana and Mark Lehman, the 2 brilliant Court of Appeals or the appellate lawyers, will be drafting a persuasive brief. That's the purpose of what they're doing, to take the facts and the law and convince the Court of Appeals that what happened was wrong, and there were errors, legal errors that should result in a reversal. And there's 15 of them, and they all live pretty much around here. And I don't want ever for them to think that, oh, he's out there, me is out there trying to put pressure on them. I don't think that's the case. I don't think that's how they would feel. I hope they would not feel that way. I'm out here trying to get truth out. I mean, that's when I do these. I'm not comfortable. People don't want to believe this perhaps, but I'm not comfortable with the spotlight. I would prefer to not be doing all this, but I do believe it's that keeping this out there for the people to listen to about what's going on, what has happened, and where we're at now helps Rick Allen out. If I didn't believe that, then I wouldn't be doing it. I don't want the Court of Appeals. They're great people. We have a really great Court of Appeals group of people. We really do. And they're going to do what's right. And it doesn't matter that I'm out here. It's maybe perhaps a little arrogant to say, oh, I'm going to cause them to not follow the law. I don't think that's the case, but I'm a little worried about it.
Yeah, look, I mean, and you're right. There is kind of that vibe of, you don't talk about a pitcher who's throwing a no-hitter. It's kind of the same concept. Like you don't. I think all of us that followed the trial, from the outside looking in, and that we went through the pleadings and we followed as the process kind of weaved its way towards trial. Those of us that understand the process all feel pretty good. And I say that with the proviso that you never know what a judge will do. But in terms of there being very powerful issues that I think the appellate court can hang their hat on if they're so inclined to do so, those exist in this case. I mean, you'll look at, a lot of cases, it's going to fall on the side of harmless error. But, so we're all keeping our fingers crossed, and you're exactly right. I mean, we do the same thing here. If people don't hear about me talking about Rick's case for a couple of weeks, they get nervous. People are always like, don't forget about Rick. I'm like, I'm never forgetting about Rick. Yeah. I'm always going to be talking about Rick. Alison and I are in for the long haul with Richard Allen in the case. So, but
let's talk about what's preventing the appeal from getting moving right now.
Yeah.
And I would like Bob to start by it's short. It is a quick read. Let's read this for the people. It is the motion to reconsider the court's ruling, the appellate court's ruling on the motion to compel transmission of exhibits.
Okay, just procedurally, just so you guys understand, there was initially a verified motion to compel transmission that was filed. Okay, and I don't know if there was a state response to that or if
there was.
So I've seen the state response to this, what we're about to get into, which is the motion to reconsider. So, but I think we'll skip the first motion, go right to the motion to reconsider. And then if Allie decides that she wants us to take a peek at what the state responded, which was basically them capitulating and saying, yeah, we agree. Like we all the lawyers involved, the AG's office, we all need these exhibits. They're going to be a part of the issues that are going to be in front of you. So they're important for us to get them into your hands. So the appellant, Richard Allen by counsel, Mark K. Lehman and Stacey Uliana, respectfully request this court to reconsider the relief provided on the appellant's motion to compel transmission of the exhibits and a new due date. In support of the request, Allen states the following. 1, this is an appeal from 2 murder convictions after a 25-day jury trial. The record includes 22 volumes of transcript, 15 volumes of documentary exhibits, 2 supplemental exhibit volumes that contain approximately 198 media files and 40 document files, and 13 volumes of pleadings and exhibits to pleadings. 2, appellate counsel has spent approximately 400 hours combined perfecting the appeal, with most of those hours dedicated to reviewing the record. So 3, during the week, during their work, however, or rather, counsel realized that the exhibits to Allen's September 18th, 2023 motion for Frank's hearing and January 20, 2024 motion to correct errors were not included in the record on appeal.
And
These,
obviously, sorry, babe, to cut in here for, those are motions that Andy handled during the trial. So we'll get into why all of that's so important. But those were exhibits the judge considered that have not been included in the record yet.
correct. And the CCS reflects the list of exhibits attached to each motion. See Exhibit A and B, list of exhibits attached to the motions. Allen's trial attorney submitted these exhibits to the court on flash drives in a binder.
And in a binder, both ways.
And in a binder. So there was paper copies as well as digital copies. These exhibits, or the exhibits, included 7 depositions and at least 8 videotaped interviews. They also include an array of documents, including surveillance footage, reports, affidavits, emails, PowerPoint, maps, sketches. They are not available on mycaseindiana.gov. These exhibits were conventionally filed with the court and considered by the judge, maybe, when denying the defense motion to suppress. See Exhibit C, order denying motion to suppress and motion for Frank's hearing on January 22nd, 2024. This motion, and this is in parentheticals, is, quote, denied based on all the pleadings, memorandum, and exhibits previously submitted in support of the request for a Frank's hearing, end quote.
And the reason they include that and they attach the corresponding order is to show that the judge is saying she considered those things. So they should, by all accounts, be a part of the actual record in this case.
Right. So the trial court also took judicial notice of these exhibits during a hearing on the state's motion to exclude Allen's third-party evidence. After the trial court granted the state's motion to exclude Allen's third-party evidence, the trial court incorporated the evidence in the third-party hearing into the transcript as Allen's proffer for appeal. I remember that unequivocally happening. I was sitting in the courtroom.
Yeah.
I think that was on day 3 when that took place of those hearings. So on September 17th, 2025, counsel for Allen filed a verified motion to compel transmission of exhibits and new due date. In the motion, counsel explained that the exhibits attached to the motions were not included in, quote, the transcript filed with the trial court, end quote. Counsel also noted that they could not file the brief without review of these exhibits. On October 3rd of 2025, the court granted in part Allen's verified motion to compel transmission of exhibit and new due date. The court explained that the exhibits are part of the appendix, not the transcript, and provided Allen until October 21, 2025 to complete the appellant's brief. The court did not order the clerk to provide counsel with exhibits.
And that's basically everything right here. That's why they filed this motion to reconsider. That's what they're asking the court to address. That's basically the end all be all.
Right. So the transcript or appendix. So the exhibits were never entered on the CCS, but are a part of the clerk's record. See Indiana Appellate Rule 2E. The exhibits also were part of the proceedings and referenced in the transcripts of August 1, 2024 third-party hearing and incorporated as a proffer at the trial. As they are part of the transcript. As such, they are a part of the transcript. See Indiana Appellate Rule 2K. The problem, regardless of whether the clerk must provide exhibits as part of the clerk's record or the court reporter must include the exhibits as part of the transcript, Allen does not have the exhibits listed in Exhibits A and B that were considered by the court when denying the Frank's motion hearing and the motion to correct errors, and that serve as part of the proffer or proffer of the excluded third-party evidence. 11, counsel is still considering whether to raise the denial of the motion to correct errors as an issue. Counsel intends to raise the denial of the motion to suppress and the exclusion of third-party evidence on appeal. Thank you very much. Glad to hear that. Failure to include these exhibits in the record would constitute waiver of the issue and ineffective assistance of counsel of appellate counsel. And that they cite Williams v. State, a 97 case, wherein the appellate counsel rather had a duty to ensure the Court of Appeals has a proper record to review the errors raised. 12, counsel for Allen respectfully requests this court compel either the court reporter, which I'm assuming is Jody, to include the exhibits in the transcript, or the clerk of Allen County to transmit the exhibits to counsel for Allen. So they've basically requested it not coming from anyone related to Carroll County. They've put it basically on the table fully of Judge Gull's County, which is Allen County, and Judge Gull's clerk, which is a woman named Jody. So 13, counsel for Allen also respectfully requests 30 days from the date the clerk or court reporter provides the exhibits to review them and complete the appellant's brief. Although some of the exhibits listed in exhibits A and B were admitted into evidence at a pretrial hearing, counsel is positive that many of them, including depositions and videotaped interviews, were not. Footnote 1, collectively, counsel spent 5 hours reviewing the transcript to determine which exhibits were admitted into the hearing. Counsel estimates that it will take at least 16 to 20 hours to review the missing exhibits. Further, it will take substantial time to amend the appendix to include the exhibits if counsel must do so. 14, the motion is not a dilatory tactic. Counsel does not have the exhibits necessary to the record on appeal. 15, because of the multitude of exhibits admitted into evidence pretrial and in jury, the record in this appeal is approximately 10 times the size of an average jury trial. Counsel has been working diligently to meet the appellate deadlines. Wherefore, the appellant or appellant, depending on how you want to say it, by counsel respectfully requests this court to compel the court reporter, or in the alternative, the clerk of Allen County, to transmit the missing exhibits and to set a new due date, and for all other relief just and proper in the premises. So there you go.
Mm-hmm.
So,
and we can just say that in the state's response, they said, we agree, it needs to be transmitted, it needs to happen. We've got no problem with an additional 30 days. And they want the court to compel the clerk or the court reporter to transmit those exhibits.
yeah, and so I mean, what's your take, Andy? So like when the lay people out in the world that follow the case are reading this stuff, they're like, oh my God, it's the sky is falling, it's more shenanigans from Gall, all the typical things that the people that are of the mindset that Richard Allen was railroaded think.
Yeah.
And I'm not going to disagree with them. Those are things that pop into your mind.
Sure.
It's unusual to me on such a highly contested pre-trial issue, such as the third party culprit stuff. I find it awfully convenient that those exhibits aren't attached, and I find it troublesome. I'm not gonna lie.
Yeah, I can tell you this much. On September the 18th, 2023, I got up, at 2 a.m., we filed the Franks memo. Two of our paralegals, Sierra and Sarah, Sierra just passed the bar and will be an associate with us in a couple of weeks when she gets sworn in. But at the time, those two were helping gather all the exhibits. It was an arduous task. If you read the Franks memo, and I recommend for anybody that has not done that, please find it online and read it. That will give you a real good primer on some of the issues, many of the issues that were raised or will be raised. And that filing just confirmed that the third party suspect stuff is going to be a part of it. I don't think that's a surprise to anybody. But on September the 18th at 2 a.m, we hit the button to have that filed electronically, the Franks memo itself. But what do you do with, all these electronic interviews and things that, Judge Gull she would have needed to watch in order to issue her ruling on whether we get a hearing on our Frank's request. And so, these are things that, again, they don't teach you this stuff in law school necessarily. So what we did was we took 3 binders. I think in that motion they said it was 2, but we took 3 ring binders, and in it we put in all the exhibits for the Frank's memo, and it was a lot. I think 160, maybe something like that, 169. And that included like flash drives with interviews between the police and an Elvis Fields, and interviews between police and Johnny Messer, and interviews between police and Ned Smith and Rod Abrams, and all these guys that were part of the third party suspect, what we were trying to get into evidence. And so in those 3 binders, like I think the way that we did it was if there was a flash drive, we would take a photocopy of the flash drive, and that would be what's in the binder. But then we had the flash drive separated and organized, and then we gave those to the judge so she could look at the exhibit. Yeah, look at that. I mean, you're going through that right now. The Odin report, there's a big one there, and gosh, I mean, and we by the way put confidential. We are the ones that did that because we weren't sure, and I think we violated the law in that some of that stuff probably wasn't confidential.
You're trying to be overly cautious.
We were trying to be very overly cautious. And then people have asked me since then, like, why did you do it? And that's the reason, Allie, we were trying to be overly cautious. But then at some point in time, when there was the writ of mandamus with Judge Gall, there was 2 of them filed on this case. One of them involved her sealing the records inappropriately. And at some point in time, she unsealed the record. But I don't know that she ever unsealed the things that we sealed inappropriately, and I believe that's up to her to unseal. So for those out there that and are paying attention to the Frank's memo exhibits, which are still have not been released yet, to my knowledge, I think it's up to the judge to release. Even if we filed it confidentially, I think the judge should look at it and determine whether or not it should have been filed confidentially. But anyway, on that day, I got up in the morning with very little sleep. I mean, I'd been working on that Frank's memo nonstop for how many weeks, and we filed it. And then I got in my car and I drove up to Fort Wayne, Indiana, with 5 binders, 3 for the judge and 2 for Nick McClelland, the prosecutor. I just gave him the crappier binders, frankly, and they were a little bigger. And I jammed everything in there because that's just the way it is. It was all the same.
What's
stuff.
good for the goose is good for the gander, right?
Well, I mean, that's a very small thing, if that's the worst.
Right. That's the worst thing. Their binder wasn't as.
Yeah, their binder, it was crammed into 2 binders instead of 3. Okay.
Right.
So I drove up to Judge Gull's court, and I think up until that point, that was the first time I had ever been in her courtroom, was on that day. And I parked, and I remember, at this point in time, everything was seemingly fine. And the June 15th hearing was a little, we had the June 15th hearing a couple months before that. That was we're trying to get Rick out of the hellhole he was in. Yeah. So things had started to kind of deteriorate, maybe in terms of, at least in my view of how things were going. But I went up because I know I say this, but I really am a nice guy. I am. And I always want to try to do things over and above what's needed. And so I thought, I'll drive up there, I'll hand these things over. And it was, I just remember the staff was kind of confused. And I said, these are exhibits for the thing that I just filed. I just need to make sure that, the judge has those. And it's a weird thing, everyone out there, because, it's a Carroll County case, right? But Judge Gall is in Allen County, which is about an hour and a half away. So I could have theoretically driven over to Carroll County and given it to the clerk of Carroll County, who's very nice, by the way.
Yes.
Very nice.
Yes.
Very good people in that clerk's office. And here's what they would have done. What do I do with this?
Right.
What am I supposed to do with this? I'm guessing that's what they would say. Do I file stamp it? I mean, back in the old days, there was an actual file stamp where they would cha-ching, cha-ching, but now everything's e-file, but you can't send in, maybe you can, I just don't know how to do it, electronic stuff. And
I mean, that's the way I have to send electronic stuff, by taking the hard copy.
Yeah.
On a disc, like you're saying.
So rather than go to Carroll County, it just made sense to me to go to where Judge Gohl was, because Judge Gohl is the one that's going to be reviewing these documents and watching these videos and listening to the audios. And there was a combination of all of that there. And what didn't make sense to me was go to Carroll County, give it to them, and then they're left with a mess of, what do I do with this stuff? Is somebody going to have to travel over to Allen County? Does somebody have to come out here? And I thought, you know what, this makes the most sense to me. So I drove up there, handed it over. Somebody had emailed me a good question, and that was, did you get a receipt from the court? And I don't think that I did. I think it was unusual for them too. I don't think there's anything wrong with them not giving me a receipt. I mean, we're all lawyers and officers of the court and their court staff, and I presume that they're not going to later on say, "Oh, he didn't give me any 3 binders." That's a lie. I mean, that didn't. I would never expect that to happen, nor do I even to this day think that would happen. Although I got to tell you, I was a little bit relieved when I saw what you just read, that Stacy and Mark, the appellate lawyers, did cite part of the record showing, like you talked about a second ago, Allie. Why did they include that Judge Gohl had reviewed these items when she denied the Franks memo? And that definitively was to show that she had it in her possession.
Exactly.
Right.
There's no walking that back.
No. So I don't know. I mean, if I were, it's hard for me. Stacy and Mark are on a different level brain wise, okay, than I am. And they know stuff. They know the rules, and they know the rules of appellate procedure and all that. So I'm never going to be comfortable saying, here's what I do because blah, blah, blah. But I would definitively, just me, Andy Baldwin, I would be wanting to see those 3 binders. I just would want those.
Right.
And I would want to actually see the flash drives, because I think I could be wrong. I think I've had this happen before, that you can see on flash drives when things were looked at.
Right. You can.
Okay.
Typically.
I think you can.
Not some. I'm not sure if you can see every time it was looked at, but I know you can see the last time it was looked at.
Yeah, at least the last time that it was looked at, and I just would be curious about that and interested in that.
Yeah, me too. And I'll go ahead and say it and take you off the hot seat. I want to know if Gohl ever looked at anything, actually.
Right.
I mean, it's that and that's for my own purient interest, because I happen to believe that she didn't read shit. I sit here right now, and this isn't Andy's sentiment at all. He's never said these words to me, but I don't believe that Judge Gohl ever fully read the initial 136-page Franks memo from beginning to end. That's my feeling on it.
Let alone reviewed all the exhibits.
Let alone review. I mean, there's no, if you're not going to read the memo, why look at the exhibits? Right.
Well, think about the August 1st hearing, where there was the motion in limine hearing, where we're trying to convince the judge that the third-party suspect evidence should come into evidence. And that was like the most crazy free-for-all day. I don't know that I've ever, you were there, weren't you, Bob?
I was.
Yeah, and it's like that's a hearing that, in my opinion, should have taken 2 or 3 weeks.
Easily.
Not 9 hours.
Right.
I mean, this is a huge hearing, and for a judge to really grasp the context of what each individual piece of evidence that we were admitting into evidence, you'd have to have almost like a foundational witness up there, and then explaining through that witness, why is this relevant? Kevin Murphy could have been an incredible witness on that. He would have been up there for days. But instead, on August 1st, what happened was, it was insane. I feel bad for Stacy and Mark because of the insanity, but it was like, we're going to be out of here by 8:30 or 9 p.m. We'd been there since, I think, 9 a.m. And then I think the judge got there a little late that day, but it was one of the days. But basically, it was maybe, I'm going to say 10 hours all in all, maybe less than that. But let's say it was 10 hours. The last 4 or 5 hours was just like, Judge, I'm handing you Exhibit 126. This is the police talking to Brad Holder on this day, and this is what that is. And I don't want you to particularly look at the 207 mark to the 215 mark, because that's something very important there. And then it's like, okay, move to admit, no objection, admitted. And then we move on to the next thing. And there's no way that anybody, outside of me, who knew what and understood the context of that, because that was my thing. That was what I was charged with as the defense lawyer, as one of the Rick's defense team. I understood what that context was of all that, of every single piece of evidence that I was giving her, and why it was important related to the third party suspect. But then Judge Gall, between August 1st and the day that she delivered the order, which was September 4th or something, she had 30 days to review. I mean, some of those interviews were an hour and a half long, and there was multiple things, and then just a bunch of depositions, and I can't even tell you how many hours that needed to have to go through everything that we admitted. You would have had to spend. That's I'm not saying that she didn't do it. I'm not saying that. I don't know what she does on the weekends, but yeah.
I mean, you're talking about a judge with a full docket. She's got other cases, her Allen County cases. She's got other things to do. She's got, trials happening. She's got motions she's reading. Theoretically, she's got motions that she's ruling on. She's drafting her denied without hearing orders for all of her cases. All the things that Judge Gull likes to do. And the turnaround, and this, and again, I'm going to take you off the hook. If Gull would have thought that she could have gotten away with it, in terms of there weren't as many eyes on the case at that point as there were, she would have ruled from the bench and said, I'm granting, because I need people to remember, for as long as the defense was begging her for a hearing on this, even if it's an evidentiary hearing to get to a full hearing, which would have been that first step, she just wouldn't grant it. It wasn't until she gave Nick McClelland the great idea. Hey, that third party culprit thing, Nick, if you're going to have a problem with that coming in a trial, you might want to file a motion. And she said that on the record, which I'm thrilled with. And I hope that Stacy and Mark, and I have zero doubt that they'll see it. They will see how this thing all came out and played out and washed out in the wash ultimately, because when she started that 3 days of hearings, which was grueling, and I can only imagine being the attorney trying to get all your thoughts together, trying to handle all the business that she was trying to cram in that should have taken place over the year and a half.
Yeah,
it was preceding the trial. She's trying to cram it all in 3 days just to cover her ass. And let's just say it the way that it is, because it's exactly what she was doing. And she told you guys at the beginning, she's like, I've carved out 3 days. That's all you're getting. She was very clear about it. So that pressure that you were feeling, Andy, you knew based on what she said on day one, that these are the 3 days that you're going to have. It's not going to go beyond that. If it goes a little long, which it did, as you aptly noted, it went till, I think we were there till 8:30 that night. Like I couldn't feel my ass by the time we left. I think I walked out, like, seriously, because it was the old wooden seats.
Yeah.
I couldn't take it anymore. And I think in the last 20 minutes, I'm like, you know what? I'm out. I've heard enough.
It was a crazy,
it was
free
grueling,
for all.
man.
It was just like, we're putting this evidence in and exhibit 347. This is right. This. And it's just like, that's not normal, folks. I mean, that's not the way that it normally happens. Normally you get people up there and they're like, hi, it's Kevin Murphy. Hi, Detective Murphy. I'm now handing you exhibit, 147. Are you familiar with this? Yes. This is my interview with Elvis Fields. Okay. What is of note of that? Is that what this is? Yeah, I moved to admit it. Now let's talk about what the contents are. And then you as a lawyer, as you're directing him, you can contextualize it through your questioning.
And you could have played the minutes the time frame that you wanted.
Exactly. Well, yeah. Great, Allie. Yeah. And you could play that, and that's out there, then everybody can hear it. And which is,
the judge heard it.
I'm a believer. Yeah. The judge heard it. And then and then you can absolutely, the judge hears it. And even if she heard it later, it's out of context with what, and then it could be, and then you could kind of like piece these things together and make it make sense for the judge, why this all makes sense as to why these people were legitimate third-party suspects that we should have been able to talk about at trial. But it wasn't anything like that. Again, I'm not just saying this to, it really was a hearing that should have taken, like, it almost was like a mini trial, honestly. And it was a mini trial that should have lasted 2 weeks, 3 weeks even.
So did the judge, I can't remember, did the judge want it more as a proffer style, or was that just a consequence of her saying, I'm giving it 3 days?
I think, I'm trying to be fair here. I think the judge did allow us to pretty much say whatever we wanted about each piece of evidence. So yeah, I remember I had these little yellow pieces of paper, and I would attach it to the flash drive, the envelope with the flash drive in it, and it would say like 2:15 to 3:45.
But she wasn't letting you call witnesses and play the evidence in court. And
I think she would have, except like Bob said, she was only giving us 3 days. And so we kind of had to freestyle there. And it's just how it ended up. If I could go back, there's a million things, of course, this is what we do as trial lawyers. You go back, but especially on this case, and think, what could I have done differently? Here's one thing. Judge, 3 days is not enough. Well, in actuality, it was 1 day. It was only on August 1st. The other day one was a motion, a different motion. And day two was about the detention and circumstances and Brad's motion to suppress Rick's statements.
Right. It wasn't all 3 days for this.
Yeah. And that was, Brad was brilliant on that day, by the way. We had 1 day. Yeah, the biggest part of the case, at least on the defense side, we had 1 day to show the judge everything. But by the way, let's get back to the Franks memo. That was almost 10 months earlier, right? And a lot of those exhibits were already in there, in the judge's possession, and presumably still are. And so that, getting back to kind of where we started, what you read, Bob, that's the exhibits have never been turned over to the appellate counsel. And you said, well, is this nefariousness? And I would say, I'm going to be gracious. I'm going to be gracious and say that it's, it was handed over, and it's in their office, and it's just something that you don't think about, like, because it wasn't at the Carroll County office, it was in Judge Gold's office, and maybe the right arm and the left arm weren't coordinated.
Yeah, but there's filing motions to compel the clerk to do it. You have to assume before they get to that point, they've asked the clerk to do it. So, as gracious as you want to be, that there's still that. And so if people are saying, well, you guys have them, your office has all this stuff, can't you just turn it over to the appellate counsel? That's not really the way the record works. No, the record doesn't work that way, because then you don't know anything.
Yeah, if what you're giving them is it's just not proper, because I could throw in there things that weren't part of the record because I found out that it helps me out, or I think that it does. Yeah. So I could say, oh, this was part of the record, and it isn't. It's important that what she actually reviewed in those 3 binders and in those flash drives, those are the things that need to be turned over to the appellate lawyers, because that's even if the judge makes copies of that, and maybe I'm wrong on this, you don't know. It's got to be the exact item. It just does. Right. It used to be, back when I did a lot of appeal work back in the day, that's what you would get from the court reporter. You actually got the actual exhibits, and they gave it to you in a binder, and that's how you got it. And it was the actual thing that the day of trial, the lawyer had it in his hand, and I'm moving to admit exhibit B, and that's what you saw, what had been in the lawyer's hand. And in this case, what I actually sent up there in the 3 binders, in my opinion, that's what ought to be sent. Right. And it should not be like Nick McClelland. I drove after I left Fort Wayne at 11:30 or so in the morning and dropped those 3 binders off. I then drove across the state to Carroll County and handed the 2 binders with the same stuff in it over to Nick McClellan. So he also has it. And, but even that is not because maybe I gave different stuff to him. I mean,
right. Or maybe he took something out, whatever the case may be.
Yeah.
And if it were as simple as the trial lawyer just hands it over to the appellate lawyer, then the appellate lawyer would just be asking Andy for it. They're going through this process because this is the way to do it. Now, one question I have, and I don't know if you know the answer, I know Michael's in the chat, if they can't get him to do it like this, the court could allow them to supplement the record as if that stuff's not in the record. Then they could get it from you.
Yes.
Then they could put it into the record. I mean,
there's
a workaround.
Rules. Yeah, there's a workaround within the appellate rules. I remember I've had to do that in the past, and but
their first option is to get the stuff that's actually part of the record.
It's bound. It's easy. Here's 3 bound copies. Here it is. And by the way, you might think as people out there might think, are you really going to turn over the exhibits to the appellate lawyers? Because that's, what happens if they monkey around with it or something. But this is an honorable profession. I mean, we're to trust that people are doing things the right way, and they're not going. You don't just presume that somebody's going to screw something up and intentionally or get rid of something or something like that. That's why you can't actually just deliver the actual thing and the actual 3 binders over to the. Now, maybe Stacy and Mark, if they heard this and they're like, nah, that's not the way it's done in 2025, Andy. That was 1994 when you started. But I don't think so. I think the preferred method is let's get the actual item that was tendered and including at trial. Now, of course, you can't do everything. Like you can't go get the gun. If there's a gun in the case, you can't. Like you're not expected as a clerk to turn over the weapons. But if you want, as a trial lawyer, think it's important, or the appellate lawyer, to go look at the gun, then you can go to the evidence locker room and do that kind of stuff.
And I've even had where there were portions of the record that were sealed and things that weren't admitted. That was in a separate sealed record that still got sent to the appellate court that I also still had access to and could visually see, even though it was sealed. I think we got like a passcode with it or something. But, so there's ways to do it. Now, All Eyes says, the AG said, anyone with it, please send it. Now, I'm going to ask All Eyes, and maybe I got to reread the response. Was that in the reply to the motion to reconsider? Because I didn't see that. I just saw him saying it should be included, period.
Yeah. I don't know that. Maybe I didn't need a closer read on that, but I don't know if it's all hands on deck. Hey, if we can supplement this record with anybody, the defense lawyers or anybody else, please turn that over. I don't know if that's what it was. I think at the time, right now, that's the workaround you're talking about, Allie. Like maybe in the end, if let's just say Judge Gall's staff in a move, they lost that evidence or something. Well, then, there'd have to be a workaround for that. I'm not saying they lost anything, by the way. I don't want that.
Right.
To be
you're
out
saying
there,
if.
just saying
you're saying if.
But, one thing I do want to say before I forget is, okay, go ahead.
No, I'll let you say that before you forget, and then I'll pull it up.
It is nice to see the Attorney General, their attorney that's working on this case. And for people that don't know, the prosecutors don't handle their own appeals. There is an Attorney General's office in Indiana, excuse me, and they have a division of appellate lawyers, and that's all that they do is they work the appeals and they draft the appeals. And so they represent, technically, I suppose, the prosecutor's office or the state of Indiana.
Right.
And so if you want to say it, they are litigants. Stacy and Mark are litigants against the Attorney General's office, if you want to view it that way. However, it is so nice to see these two litigants, these two groupings of people, the defense appellate lawyers and the AG's office representing the prosecutor's office, getting along and, trying to find the truth. That's what I loved. I was so heartened by the response of the AG that they said, yeah, you know what, they need the evidence. And the AG don't want them to have the evidence or to have to write their brief without getting the evidence. That wouldn't be right. So we are on board with the 30-day extension. Once they receive this missing evidence, we are on board with that. And I just think I shouldn't
Commendable.
we
shouldn't be shocked, but
I shouldn't say it's commendable. It's the right way
normal,
to practice law,
right.
And it is normal. And hats off to them, because we're all after the same thing in this case, and that's the truth, getting to the bottom of what happened. And I think that the AG's office I appreciate that, the collegiality that was missing in our case, and that I actually have all over the state with all kinds of prosecutors, different personality types that I get along with, and judges and everybody. And that just, to the extent that was missing, you're not always going to be happy with every judge or every prosecutor and going out and having drinks with them after the trial. But I do like that part of the profession for doing this for 30 years. I do love that we can box each other in the courtroom and punch each other in the nose and then go out afterwards and talk about what happened. And I think that seems to be the case here with the AG's office. And
Right.
Stacey and Mark. And Stacey and Mark, by the way, are very well known in their jobs. And so I'm sure there's a lot of respect for them.
Right.
Yeah.
So here's the response, and I'll get to what All Eyes was speaking to. I interpret it a little bit differently. So this is the AG's verified response to the motion for reconsideration of the motion to compel transmission of exhibits and a new date. So they say Allen's motion advises that the evidence submitted to the trial court by the defense in support of the motion to suppress and the motion for a Franks hearing is not currently included in the record available in this appeal, and that it is relevant to an issue the defense intends to raise on appeal. Now, paragraph 2, I just got a text from Sleuthy. This is what everyone's talking about as far as, well, they said whoever has it, send it. But what it says is, Allen's motion rightfully points out that the appellate counsel do not have access to those exhibits, as they are not available through the trial court docket or the exhibit volumes. The evidence needs to be provided for the appeal by whoever currently has possession of it at the trial level. So just for you guys out there, that means at the trial court level. It doesn't mean, I mean, I don't interpret it that way, and I can't imagine that it meant anything more than that. Do you interpret that as meaning including you, Andy Baldwin?
No, I don't. I think it's that confusion I talked about earlier between the Carroll County clerk and the staff in Judge Gull's court, with whom I dropped off all of those exhibits. So,
but I completely understand from a layman perspective how that sounds like anyone at the trial level. That would include.
All right. Well, I'm going to give you both a little bit of pushback. Osbrook is in chat, and he's had a fair amount of experience with post-conviction work. So Michael says there is no problem with Andy just giving the appellate jockeys, and I'm assuming he's talking about Mark and Stacey, the Franks exhibits. And then he goes on to say, what needs to be done is to check with Gull that she had everything that Andy gives the appellate jockeys. This is quite simple to solve. And then finally, and Michael had a few other things. He says, yes, I was one of those deputy attorney generals once. They can get it from McClellan. So in a world in which all else fails, all right. And again,
we said that when all else fails.
Yeah.
Well, what Michael's saying is it doesn't have to be when all else fails.
Well, you need to listen to Michael, because he's probably listening to me and like, Andy Baldwin didn't know what the heck he's talking about. But
well, I just assume that I know you have a relationship with the appellate counsel, that if they thought it was that simple, they would have just called you and asked for it.
Yeah, I'm not. Yeah, I'm letting Stacey and Mark run the show, and they're doing it. They're doing it.
All right. Well, maybe you should just send everything over to them.
Well, you should see the Delphi room where we have everything under big time lock and key. And you know how it is, guys. You know exactly how it is when you're getting ready for trial.
Everything.
And then after the trial, we've got just 50 boxes filled with crap and vertical file cabinets and horizontal file cabinets. And it's like, it would take a minute for me. I had everything at one time, all the Frank's exhibits in one place. And I'm like, this is sacred here. We got to not dig into that. But then you're working on a Frank's number 3.
And you need it.
And then you're like, okay, I got to go back and get that. And then you take it out and you intend to put it back. And then it ends up in another box. And so it's not, these are the trials and tribulations of a big case with lots of documents and stuff. And,
well, let me ask this. Is what's contained on the 2 flash drives all of the hard copy that's just been scanned in?
It's been a minute on the motion to correct errors stuff.
No, I mean, did you
The hard
have
drives.
flash drives for the exhibits and the?
Yeah. We of all the audio and video was done on flash drives.
Oh, so the paper was not scanned in and put on the flash drives.
No.
Okay.
No. If I could do it over again, I probably would have done it that way.
I mean, because if it was that way, I'd have to make a drive to Indianapolis and come to your office and say, "Here, man, I'm going to run that over to them for you." So I'll be the bad guy, and I'll say, he didn't want to bother you, and he knows you're very busy, and he doesn't want to. I would have been that guy. All right. So, I mean, I think that answers the questions.
But let me finish it because it's real short.
Okay.
The state agrees that the evidence was considered by the trial court when making its evidentiary rulings. The state also agrees that the evidence needs to be part of the appellate record. Appellate counsel for the state likewise do not have access to these exhibits and will need to be able to review them when preparing the state's brief. Granting the relief requested in the motion to reconsider will save delay later in the appeal that will arise if the state needs to file pre-briefing motions seeking to obtain evidence relevant to an issue on appeal. And if it should prove necessary to pursue an appellate Rule 31 proceeding to recreate the evidence, it would be preferable to do so before any briefings are filed. Yeah. And that's what we're talking about right now. I assume that's the workaround. The state has no objection to Allen's request for an additional 30 days from the date on which the exhibits become available to appellate counsel in which to review this evidence and file his brief. The prosecutor has advised the state that the evidence submitted by the defense in support of the motion at issue was voluminous. The state also anticipates that problems may arise in navigating the unique challenges of trying to include video or digital evidence in an appellate's appendix. The state believes the request for an additional 30 days after the evidence is received is warranted and not a dilatory tactic. Counsel for the state has reached out to Allen's counsel to express its willingness to work with them and at the clerk's office on how to best resolve any logistical issues that arise with respect to including the evidence at issue in the appellate record. Wherefore, the state has no objection to the relief requested in the motion to reconsider.
Yeah. And so as we sit right now, we have an order that came down from the appellate court that's dated 10/3, wherein they have given Stacy and Mark until the 21st to file. Obviously, they filed that prior to them getting the AG's response. So I'm assuming we're going to get an updated court order, probably granting them the 30 days from the date that they are in receipt. I'm hoping that the appellate court puts a drop deadline on there in terms of when they have to turn it over.
I know. Yeah.
When it has to be transmitted.
Right. Yeah. When it has to be transmitted over, because I mean, this thing just can't keep going on in perpetuity because, we've got a guy sitting in somewhere in Oklahoma, kind of waiting for this shit to all go down. And, just kind of the way that the process is going to work, you're talking 30 days after, and if we're talking end of the month, when that finally gets transmitted, Stacy and Mark go to work on it. They're able to hammer it out. They can get it done in 30 days. I happen to believe, and I think that Osbrook kind of like threw this out in the chat as well, that, kind of this we're playing nice right now by the AG is really kind of building that rapport so that down the road, when they're having to ask for extensions in time in order to put their response on file, that, they're going to get the same courtesy that they were giving Mark and Stacy. So, I mean, they're, and
which is the way it ought to be, by the way. I mean, it's just the way that we all, in a professional world, this is how we operate. It doesn't need to be mean and nasty.
Right.
I mean, there comes a point in time where maybe something has to be done, but but yeah, it's, I'm just glad. I should not be like, why am I going on and on about it? Because it's not been the way that it has been on this case. And so I'm going overboard on stuff that, those AGs, they're the top AGs probably, I've heard that at least, that are working on this. So I'm sure that Stacy and Mark have dealt with them before, and there's a lot of respect going that way toward the AGs people.
I'm sure.
Yeah. And by the way, I wanted to also say, when I do disagree with something that Stacy and or Mark said in their motion, and that was that we think we can review the Frank's memo stuff in 15, what did she say? 15 hours,
20 hours.
Maybe. I thought that sounded like a little.
Yeah, I mean, I think once they get it, I'm wrong. I hope I'm wrong. It's just, there's a lot there.
There is, and it's going to live in that world where Judge Gull loved to hang her hat that, she didn't find that there was a nexus, despite the fact that there was, at least a couple of confessions, one of them from a person who claimed that he left DNA on Libby's head, Abby's head. And, you've got a guy who claims that he has an alibi, which only works if you believe that the state's timeline is the timeline, which I don't, I never have. And he's got a son that dated Abby. To me, I'm not sure in which world that doesn't amount to a nexus in terms of a connection between the victims and, these people that they're, the defense is alleging may have had a hand in this. So I don't know. I mean, there's a lot there. And like you said, I really hope that they bolster that argument to the point where, the appellate court's going to look at it and be like, yeah, you know what? I think she screwed up on this one. And I can't see a world in which this thing turns out to be that in and of itself is harmless error, because if you're introducing that at trial with that type of evidence, and had you been able to try the case the way that you wanted to, and were able to get the photographs of the girls and the strange stick formations on, and then we're able to show these strange pictures and the timing of these odd posts on Facebook by somebody who's mimicking the crime scene and whose son happened to be dating. There's just a lot there. There's a lot there, and
that's even the tip of the iceberg.
Had anything to do with it?
Tip of the iceberg.
No, we don't know whether they had anything to do with it. There could be a setup. I mean, there's a million different things, but we as defense lawyers, he has more
a right to present it.
Yeah, Rick has a Sixth Amendment right to present this stuff. And by the way, I wanted to say, it's not just third-party suspect stuff generally, that there was something important that happened during trial that I don't think got enough talk. And that was when Jerry Holman got up on the stand, and others as well, and said, we think that the stick formations on the girls was an attempt to conceal the bodies. Okay.
Open the door. He kicked the door wide open.
Exactly. The prosecutor
put forth a theory
of what the sticks were on the body. And then to make it worse, and there was a moment, and I think I talked about this in that long podcast we did right after or a couple months after the trial, but there was a moment in the trial where Nick kind of stepped in it, or Jerry stepped in it. It was on a redirect. And sometimes, man, you guys know this, sometimes the best redirect question is no redirect question, because then that's where I've had it happen to me. I've had I'm going to ask this one more cute little question. And then all of a sudden the wheels start falling off where you should have just shut up.
Yeah.
And that did not happen here. And Nick, I think it was Holman, it could be somebody else, talked about this thing called an undoing as another possibility. And I remember as soon as I heard that, I'm like, holy crap, it's not enough that they said that it's the sticks, their theory of the sticks on the girls is to conceal the bodies. That's the state's theory. But now they have a second theory, and that second theory is it's an undoing. And an undoing is a psychological term in that
you feel guilt.
Yeah, you feel guilt, but it's misunderstood. Our expert, ritualistic crime expert, Don Perlmutter, who literally wrote the book, as you know, because she was on your show. She literally wrote the book on a ritualistic crime scene. She totally said it's not an undoing, but that's the sideshow. The real show in the courtroom on that day was I looked over at Nick, and he saw me go like that. I felt this. There's things that happen in the well of a court where he like caught through the corner of his eye, like, oh crap.
He should have.
What just happened? And I don't know that he understood at that moment, other than to say, Andy
perked
up then. Well, then if you go back, and you guys might want to do this, just when you sometime review the motions, 2 motions I filed during the trial, which is not completely unusual. I mean, sometimes you do file motions during trial, but it's
unusual. Right.
And I filed 2 motions saying they kicked open the door, as you said, Allie. And because if people aren't following along, we had our own theory about what those sticks represented on the girls and why they were on there. And so we're not even talking about third-party suspects then.
Right.
It's not like we're pointing the finger at particular people. We're just saying, hey, the jury has a right to know that there are people out there that think this is a ritualistic crime scene, and to debunk what the state said, that it's a covering. Well, how does that help Rick Allen? Here's how. Because Rick Allen has no connection at all to Odinism, Norse paganism, ritualistic this or that, cults. There's nothing that links him up to anything. So if the jury is left even with just this, we have a ritualistic crime scene expert said this is textbook ritualistic crime. Rick Allen has nothing to do with ritualistic crimes. There's nothing on his computers. There's nothing in his past that show that
he's got any knowledge in that field.
And DB is right. It was Cicero was the one who brought up the undoing stuff. Like, so they're a guy who had the whole theory. He had a whole alternate theory, that Libby. It was Libby's hand on the tree that made the F thing. It was like he had the blood flow and which way it went. He had his whole cooked up an entire theory. Yeah.
And look, I just want to connect the dots even more for everyone who just,
please.
We're lawyers, so it flows for us. So what Andy is saying is that, putting aside the third party culprit, that the defense had the right, and Richard Allen had the right to present their theory as to why the crime scene looked the way it did. And by the state putting on evidence explaining why they think the crime scene looked the way it did, it was an undoing. Even more than it was just concealment, it was an undoing. That they were literally presenting a theory as to why the crime scene looked the way it did. This was Abby's hand that made this blood. It was this that made that blood. That opened the door for the defense to be able to put on their evidence that this crime scene was staged intentionally to look an intentional way that meant something important to the killers. Whether or not, you don't have to say anything about anybody else. You don't have to get into third parties. It meant something to the killers that speaks to knowledge and significance of Odinism, of what are those
Norse
things?
paganism.
Right.
Yeah.
Whatever the case may be, that this demonstrates the killer had knowledge of this, and there either could be staging whatever, or that this was significant to them for some reason.
Yeah,
which there was no evidence that Richard Allen had any knowledge of any of that. That's the significance of it.
No, and I think this conversation that we've had over the last 10 minutes is just a nuanced concept that really has not been talked about or viewed that much. So I for those out there that are watching, read those motions that I filed during the trial, and then here I am at trial, and I'm walking on pins and needles with the judge the whole time, trying to because I don't want the jury seeing her animosity, if there was animosity toward us. I mean, you were in the audience.
Yeah, hey, Andy, I got news for you. She hates you. She cannot stand you. She's fine with Brad. She's fine with Jennifer. You make her skin crawl, bro. And I have no idea why. You're frankly, like, you're probably the kindest guy out of any lawyer that was in that room, just in terms of general demeanor. And you're not confrontational. Like it befuddled me, her distaste for you, which I could sense immediately. Like, as attorneys, I always know when there's a judge that hates me, and I'm a big mouth. You know, I know I give them a reason not to like me. They're like, oh, there's
This
big
guy.
mouth again.
Here's this guy again with his
You're
with his
not that
bitch of a
guy.
wife.
You're homespun. You're like,
Yeah.
like
You're
I said, man,
humble.
like I expect you to bring a rocker in there and put your pipe in and just start fucking like.
I can be confrontational, and there was moments where
Even when you're confrontational, it's deference.
You're still nice.
Well, I mean, there was a moment when Steve Mullen, the investigator, got off the stand on his.
You did get his ass,
and I walked over to him and I said, "Shame on you, man." And Holman and I had gone at it. I mean, Brad, actually, what's funny is Brad is way less confrontational than I am. And he would like hear me and go after Holman, you know, and he would be like, how can you do that? You know, how do you do that? And so I am capable of that when I would call it more of a righteous indignation than anything. I'm very capable of getting righteously indignant, big time, actually. But yeah, I want people to think about what we just talked about, and then go to the record, because I haven't looked at the record.
Send me the 2 motions, and we'll do a live on them.
Oh, okay,
I don't know.
yeah.
Send them
I'll do that. I mean, for those who think that I am online and looking, I know stuff is out. I know that the at some point in time the transcripts got released, and there's all kinds of conversations going on about this and that. I don't know. You know, I have a few people that email me that are really great, and they're really all fact. They're like just focused on facts, and I won't say who they are, but if they're watching, they'll know who they are. They're like, hey, there's a bunch of pages, for example, redacted on depositions that one person sent me the list, and I'm like, well, who in the heck thought that it was appropriate to redact anything without having some type of court hearing? Or I'm not really, maybe it's totally appropriate. Maybe Michael Osbrook will say, no, the judge can do that without having a motion in front of them.
I've never heard of it.
But
yeah,
apparently,
unless it's like a child's date of birth, you know.
No, we've got an army of cranks out here that are they're on top of all of it.
Yeah,
you know,
why call them cranks?
It's embarrassing.
They've adopted the moniker that the murder shits gave them, and they've embraced it, and they've taken it as their own, and they've claimed ownership of it, and I love it. And they are every single one of them that it does huge amounts of work on this case.
Oh my, it's insane.
It really is, with the like just gaping holes that they have to deal with in terms of, you know, they're getting, as I said, redacted depositions. They're getting, you know, the exhibits finally come through, and there's gaping holes of exhibits which seem inexplicable as to why they haven't been released, and they just still are able to do incredible work, you know. And I know the last time you were on, you made a promise, and I'm going to hold you to it. If this man gets another trial and you try the case, you're gonna access and use these folks that put in an incredible amount of work 100%. That are all brilliant. All of 100%.
I'm embarrassed that some of the facts that these people know that I don't know, and I just you know, we only have so many hours in a day, and I'm not trying to make an excuse. It is, and that's why it was more important now than ever to employ these people, not employ them money-wise.
Right.
Maybe, I don't know if that's possible, but these people have such a passion. The people that are emailing me, there's a lady in Texas, I don't know who she is, but she's like, and what's interesting about most of these people is they're not out here espousing theories. They're about transparency. That's what they're all about. And I love that, because
they're about justice.
Yes.
They're about transparency. They're about justice. Sleuthy, who is, you know, one of our ride or die cranks, just posted a beautiful thing on Twitter today, just talking about kind of like a cause. You know, you have to decide what you're doing, and if your cause is regarding an individual, and that's, you know, and you're considering that to be a movement or a cause, it was really well written, and it was so gospel. Because
it's not about just one person.
It's not about an individual. That can't be, you know, here, you know, we have a lot of people that watch this channel that care deeply about Rick Allen and Kathy Allen, and that justice be done in this thing. And it's like,
but they
people
have
kind of
passion for
lose sight.
justice overall.
They absolutely, like, I mean, that extends beyond, but they realize that this case in particular, because of the way that it went down, is such an important case to shine a light on, because like you said, we really just scratched the surface of the issues that have arisen in this case. And they are, I mean, Mark and Stacy have like an absolute mountain of issues in my estimation, starting all the way with Osbrook's chronic claim, and like, people want to kind of say like poo that, but that, like, Michael Osbrook is a brilliant lawyer. He knows his shit. And when he laid that out for me and I read that and he put it in, obviously, the motion to correct errors, I'm like, that's a winner right there. It's like he laid it out, and it's kind of like this simple concept, but the bottom line is that they did it. There's an absolute chronic claim there, and it should be that simple.
Yeah, and and Michael apparently is watching. I have not talked to him forever. I hope he's doing well, and his brain is still operating at that high level that it operates, and it sounds like it is, as he's probably like, and poor Andy and his lack of knowledge about appellate rules and whatever. But Michael, on that chronic issue, not only did he like nail that and find it and cultivate it, but there's also this whole thing that's going on involving Tobe Lesenby's change of story in an affidavit that I'm presuming Nick McClelland penned, that all of a sudden Richard wasn't sent to White County because they were in fear and they didn't have the ability to house him in safety. It was because there's an overcrowding issue. And somehow, and it goes, I don't remember all the ins and outs, but it has to do with, it seems to have to do with, to get around the chronic, you better say that there was an overcrowding issue. That's kind of a simplistic way to view it. That's the way that I viewed it. And that's also, like, I don't know how Stacy and Mark are going to be able to get their arms around all this and get into that much minutia. They're going to have to pick their poisons. I mean, you can't go scattergun in an appeal, I don't think. Normally, we focus on one or two issues, and maybe three. In this one, they're just the one that we just talked about a second ago, about the motions that I filed in the middle of the trial. That's an issue right there.
Right.
That's an issue.
So many.
The chronic, that's an issue. Third party suspect, that's an issue. Our motions to get Judge Gull kicked off the case, to disqualifier. I think there was at least two of those. That might be an issue. I think it should be considered, but that's all the brilliance of and I know they probably get tired. Stacy is super humble and Mark is too, and they probably get tired, but they really are brilliant. I mean, I'm not just saying that they really are. And so they're going to figure it out. They're great writers. They're great thinkers. They're going to figure out what all that is. And at the high level, like a Michael Osbrook has, they have that type of brain power. So,
and I'm just going to say, before we shift gears and we'll wrap up with Alan and bring Max Wiley on for the next phase of this, is that it sounds like you guys have at least some of the exhibits were on a zip drive. So it sounds like there's at least some of those exhibits that if the appellate counsel needed, you guys have digitally that you could get over. Maybe Max can hunt those down. I know he's your digital guy too.
Max Baker.
Oh, that was a different Max. That's right.
Oh, Max.
Yeah,
well, by the way, I just heard, for all those Max Baker lovers out there, I mean, Max, who took the stand and was really terrific. And if anybody followed the case, they would remember him. He just reached out to me. He's in his first year of law school. And so I'm trying to lure him to work with us as an intern over the summer. So
be a good get. It'd be a good get.
Big time. But if we, Allie, to answer your question, whatever we have, my paralegal would have to track down. I mean, it's on the computer if it's there. She does a great job of organizing stuff. I just don't know. I don't know where anything is because it's not my.
Babe, do we have anything else Richard Allen to discuss before we bring Max Wiley, as in the partner?
Yeah, there's one
screen.
thing, and I saw Spoogs just reminded me, because I told her to remind me. I'm trying to find where, like, Spoogs, did you post that as a reply to my tweet Send it to me. DM me your question in Twitter so I can ask.
Okay,
Andy.
so if I see what Shaboogs put up on the super chat, if it is that, we cannot ask Andy about that, because that could become a post-conviction issue. It could become it's not something that Andy should speak on.
I didn't
By
see
the way,
it.
I saw that did you have the Karen Reed attorney on?
Yes,
I did.
There's been a lot of talk. I don't know, a lot of talk. When I do these podcasts, sometimes I'll look at the comments, and that's just something you shouldn't do as a lawyer. I mean, there's mainly good stuff, but every once in a while, there's somebody who's like, she should have had, Rick Allen should have had Karen Reed's attorneys. And to that, I say, yes, I agree. I would love for Mark Betterow. Is that his name? I didn't.
Yeah,
No,
Betterow wasn't one of the
Betterow's-
lawyers. No, so it was David Yannetti, Alan Jackson.
Okay. I don't know.
And then Bob Alessi came
Alessi.
in.
And don't
the
forget,
difference that they had, Andy, is that they had 2 trials to get it right, and which they did in the second trial. And they had all the money in the world, and they had little to no resistance. There was a third-party culprit issue there as well.
Yeah.
And theirs was allowed to come in under the theory, which is a Massachusetts case called Bowden, wherein it's basically that it was a bad investigation by law enforcement. And because of that, she was going to if they could develop their theory through that. And they did through the first trial. And they really didn't even need to, because ultimately what happened in their first trial is the prosecuting attorney who tried the first case decided to front it all. So he wanted to try to get ahead of the defense in their third-party claim that something had happened in the house. So they put all these witnesses on, and he got into it.
Defense got to cross-examine them. Oh,
the second trial, they trimmed all the fat.
Babe, check the supers to see if that reminds you if that was Shaboogs.
Yeah, it is. It's definitely the white car question.
Which she means van, right?
Van.
No, there's a car.
Oh, well, there's something different than maybe
it's a timing issue with this. When the evidence started coming out to the public, there's clearly a white vehicle that drives by on that road that's caught on the video. A white vehicle that's not a van, that happens to be right around 2:07 p.m., which is right around when the picture of Abby on the bridge with nobody behind her in the distance is taken. And then minutes later, at least according to the state's theory, the girls are.
Yeah, somebody had emailed me about that, and if we just missed, if you're talking about a PCR, I'm going to fall on any sword I can, because if I screwed up anything, and I don't have any issue with that. There's, you can make excuses and say there is just so much going on. Even if we had the most, awesome relationship with the judge and the prosecutor, there's still unbelievable amount of stuff out there. But yeah, there's things that we could have focused on differently for sure. Well, and what I also want to say is I've told Rick and Kathy this. We like each other. I like Rick and Kathy a lot, and they're fond of me, I think. And that does not mean that I should remain on this case. It doesn't mean that. He needs whoever is best for him. And I think you're best for him at retrial. Every lawyer, especially in this case, Andy, there's literally no way to even conceptualize every possible alternative of things. Like, I thought she was talking about the white van issue when I was saying, like, I don't want you to speak on that. So I didn't even know about this, possibility that a white car passed by around the time could the killer have exited from that vehicle. It sounds like. I don't know if that's the person that emailed me, but somebody just emailed me about that. And I'm like, whoa,
it could have been any of the cranks. But
well, I mean, I think what they're saying is that car could have gone there under the bridge, and then it's, this is, down the hill, go down to this car,
that's the insinuation.
Yeah. Then which fits in with our theory that the phones were in a car and they weren't, that's why the phone wasn't moving any longer. I mean, it goes into all.
Yeah. And like my theory, and I saw somebody posting it, and like somebody recently, I was always of the mindset that the bridge guy, whoever that may be, actually came from the South. and meaning that the side that the girls ended up going down, and they walked past the girls and then turned back around. I don't think anybody came from the north end of the bridge.
No way.
You know,
it's always been that way for me. I've always believed that there's multiple people, and now that there's a lot of people that are watching the video over and over. I talked to a lady in England who super nice lady, and she saw some stuff that opened my eyes too about maybe a person down, that you might be able to see somebody down under the bridge when there's a real quick flash through. And so, and I looked at it and I'm like, oh, well, maybe, yeah, wow. And so that lends itself to the theory that, yeah, somebody was down there and somebody, and then there's people that say they hear whispering and things on the audio.
I thought I heard something.
And I agree with you, Bob. I mean, even a juror asked that question. I think I remember, where couldn't it have been at the south end and they walked past him and turned around, which has always been my theory. That's why that 207 photo to me is a huge deal.
Huge.
People that don't that say, oh, well, that doesn't matter. He could have been. Listen, okay, if what there's, I'm sorry to get on my high horse here, but if Betsy Blair did see Richard Allen at whatever, close to 2 o'clock, if that's who she actually saw, he was out, then this person she saw was out on one of those little side stage areas, the platforms. And so think about the timing here. You've got Betsy Blair saying that she sees him and then she walks this way and she passes Abby and Libby, according to her testimony, as they're heading toward the bridge. That's not that much time. Richard, if it were Richard or whoever it was out there, would have had to have, for whatever reason, let's just go with the state's theory that it's Richard Allen. Richard Allen, according to Betsy, she thought it felt like she said, it felt like he was waiting for somebody. Okay. He's out on a platform waiting for somebody. She turns around, they pass her. Under the state's theory, Richard Allen then would have had to have gotten off the platform, because you can see it in the 207 photo, walked past the girls into the woods, or maybe as soon as Betsy Blair left, he goes into the woods, waits for the girls, and then waits until they're over halfway across the bridge and then starts following them. Does that make sense to anybody? Or does it make more sense that if it were Richard Allen, he would remain out on that platform, then the girls would pass him, and then he would start following them, and he would be in the 207 photo.
He'd be in the 207. Right. Therein lies the rub. For that
and so
entire, you know.
We're going to focus, if I'm back on it, if that happens, that 207 photo is going to be a lot more talked about.
Because otherwise,
this is the final thing. Let me get this out. Yeah. Like the final thing that I want to say in terms of the representation, like Osbrook and I were both of the mindset, and this is all under the umbrella that the threat to Rick's existence on this planet was real. Like in terms of him making it to trial, in terms of what he was going through, was a real, genuine concern that we have to get this man to trial, because we're afraid that he's not going to be alive for too much longer, because that case, Andy, required 3 years to get that thing ready to trial. Any lawyer, if you were to sit down and you push that all in front of us and said, all right, man, like how long do you think you're going to need to be able to prepare this where you can get through everything and understand everything and prepare an adequate defense in terms of what the state is trying to say here? It's a 3-year deal, 3 years to prepare for that type of trial with that much evidence. It was incredibly complicated. I mean, you guys were put in this position where you're ripped out of the case, which again, sadly, I think is probably not an appellate issue because you were reinstated by the Indiana Supreme Court. But the reality of the situation is that in the middle of your representation of this gentleman, you're ripped out of the case. Your discovery is taken away from you.
And
Rick, state.
And we were going to file a speedy trial for the very reason Rick had signed it. I don't know that people know that. Rick Allen had signed a blanket speedy trial and said, you file it whenever, we had talked to him and said, we're going to file this, and we were going to file it, go 70 days from that January, 4th trial date, whatever that first trial date was in January of 2024. We were going to back it up 70 days in Indiana, and we're going to lock in that date. And that 70th day would happen when we were either kicked off or about to get kicked off, and everything was going haywire. And so it's not just what you said, Bob, that we were without discovery when we weren't representing him. And Rick was even unrepresented for a period of time, which is also ridiculous. That judge told us not to work on the case or talk, for it was a number of days. But also he lost out on his speedy trial right because we were so desperate to get him to trial because he was in such a bad way. And so when we got off the case, by Gull doing what she did, which the Supreme Court ultimately said was wrong, Rick Allen had lost his speedy trial right over that. And there was a lot of things that happened after January of 2024 that, that would not, I think they would have been in bigger trouble at that point in time. Right. So, yeah.
All right, I'm going to introduce Max or bring Max on, and then I'm going to leave you guys because, Bob, I hate for lawyers. I just don't think everyone gets a fair chance to talk. But I'm going to say hi first. But maybe is there a better way? There we go.
Look at him with all his patience, sitting back there listening to us yammer on about Richard Allen.
Hi, Max. Nice to see you again. I know we had you on before to discuss this very same case.
Good to see you. Good to see you. Thank you for having me.
Welcome, my friend. So,
all right, I'm going to leave you boys to it. I love you all. Bye, everybody.
Love you, honey.
Yeah.
All right. Well, welcome, my friend. Thank you for your patience. When we get on a Richard Allen rant, it just can get off the rails. So I'm sure you're used to it, considering that you practice in the same office as Andy does. All right. So, but we do want to shift gears, and we're going to shift over, and I hope that everybody stays. I know that there's people that are obviously passionate about Richard Allen, but there's a lot of connective tissue between this case and Richard case, and the primary thing being Judge Gull sat on this case. And it was the very next case that Andy ended up trying. Let me just kind of give people like an overview, or one of you guys want to give an overview of what the Alison Davis case was? Max. Why don't let's do it that way.
Go ahead, Max.
Sure. So our client, who was found not guilty and was innocent, we very firmly believe was charged with the murder of her husband. Her husband was found at the bottom of the stairs. That's where she found him. That's basically what she knew about the situation. She woke up to him at the bottom of the stairs. She had no criminal history of any kind. There was no motive to point to for why she would do this. But the state just became convinced that it had to be murder, based largely in part on a pathologist that developed a theory. And then they brought in experts to try to corroborate this theory that ultimately didn't make sense. And so we were in a position where we had an innocent woman facing going to prison for the rest of her life.
Yeah. And in terms of some of the stuff that you guys were able to develop with respect to, because there was very powerful evidence, and I had a conversation, obviously not on stream, with Andy, where he was telling me about the Fitbit and some of the incredible evidence that was really portraying in terms of, in my estimation, completely exonerating your client, because as if you know or don't know, a Fitbit keeps track of your heartbeat, your steps, all that good stuff. And so what ends up happening with that, kind of flesh that story out in terms of the Fitbit and how you guys come to find out that information and where it goes from there.
Sure. So the Fitbit was completely exculpatory. It completely backed up what our client had always said happened, that she was asleep and then woke up suddenly to her husband at the bottom of the stairs. Her heart rate with, this granular minute by minute data supports that. And there's no fabricating this data. This is, you can take it to the bank. And so it took a long time to be able to develop it, just in part because it comes in this proprietary format. And so we had to bring in experts to figure out what exactly it said. The state actually got it from a search warrant because they knew she was wearing a Fitbit and knew that
Garmin,
evidence. Correct. Yeah, that's a good point. And so the state got the evidence, but we had to find experts to figure it out because their experts couldn't figure out what it meant. So we had kind of the best folks in the field, Dr. Keith Diaz from Columbia University School of Medicine, was the leading expert. He's testified in, the majority of these cases. There's not a lot because it's relatively new technology, but it was totally exculpatory. And so then once we figure this out, rather than dismissing as the state should have, because it showed she was innocent, they then argued that it wasn't sufficiently reliable, and Judge Gull went for their argument and excluded this very important evidence in the trial.
Even though they did not put any experts on at all, the prosecution, to debunk that, or to support their claim.
So it was some Ipsy Dixit, like, somebody just said some shit like, oh, this isn't reliable. So nobody of note, nobody with any expertise in that area. There was just an Ipsy Dixit that happened where, kind of like a Nick McClelland or a Hank Brennan in the Karen Reed case. He was infamous for Ipsy Dixits where, he'd just say, well, this doctor shouldn't testify because of X, Y, and Z, and provide no actual witness testimony. And the judge would oftentimes agree. So, I mean, like going into that case, I mean, when you get a blow like that, like in terms of a judge saying, okay, I'm not going to allow this evidence to be admissible at trial. I mean, how do you recoup from it? Because I mean, that type of evidence is like, just knocks the wind out of your sails when you're like, what were you thinking when you walked in? I'm not asking you, Andy, because I know what you were thinking, in terms of when she makes that ruling. But Max, what's going through your mind when she rules against you on that thing?
It was very demoralizing, certainly. I mean, we, at that point I'd seen what she'd been doing on the Delphi trial for some time. And so we weren't really surprised. I mean, we were building the record for appeal. We, definitely considered that she might do it. It still seemed just like there was no basis to make that ruling. So it was tough. And at the time it was, we were set for trial in 3 weeks. And so, that's a major blow to your defense strategy to suddenly have very highly exculpatory evidence taken out of the picture.
So what do you do? So what's the pivot? Like, what do you guys decide to do? I mean, Andy and Brad and Jennifer had to deal with the same thing once she cut them off the knees, and essentially they couldn't produce they couldn't put forth any type of evidence. They basically had to lean on reasonable doubt. So, I mean, what did you hang your hat on once that was excluded?
Well, so we had a medical expert that ended up being the star of the show, Dr. Dragovich, who I think Andy certainly would tell you he was the most compelling witness of the trial. I was busy doing his direct, so I was kind of in tunnel vision walking him through that. But I think at the end of the day, it seems like he really was a major factor. So that was fortunate to have. I mean, we were prepared for that ruling. We knew that was a real possibility. And then, so we weren't completely caught off guard. And then I think we kind of shifted our focus to the weaknesses in the state's case. And it worked in the end.
Yeah, for certain. And, had you tried a case in front of Gull prior to that, or was that your first go around with her?
That was my first go around with her.
And, and one of the things that I can't not ask in terms, and I probably asked it the last time you guys were on, but I can't remember, in terms of Andy being your trial partner on that case and him just coming out of this case with Gull, and what the result was there. I mean, did you what was your conversation? I'm not asking you to get in any kind of, privileged information, but in terms of the two of you guys as two lawyers that work in the same practice and are partners, were you ever like, well, Andy, maybe you don't want to try this case, or Andy, do you go to Alison and say, look, I mean, this is kind of my history with this judge. And I am concerned as your attorney that there's going to be, some residual things that may follow me from the representation of my last client that I had in front of her into this case. And I don't want that to happen to you because it's a real thing, and it's an actual consideration.
What's your memory of that, Max?
Yeah, I mean, it loomed over our representation of Miss Davis the entire time. And I know Andy at certain points was like, they're going to want their money back. They've, Judge Gull's done whatever on Delphi, and they're going to, our other client, Miss Davis, their family's going to see that and they're going to want us off the case. But fortunately, our Miss Davis's family believed very strongly in us, and I think believed very strongly in Andy, and so they kind of tuned that stuff out. I mean, they were well aware of what was going on with Delphi, but they saw the truth. And
we had told them about it when they hired us. I mean, because when they hired us, it's when we had been kicked off the case, or however you want to characterize that. Right. So they hired us during that period between October of 23 and January of 24. And they hired us in December. Yep. So we did make them aware at the very first hearing, but I think what Max is saying is after, it just got worse and worse and worse, perhaps in their eyes. And I was concerned that it wasn't that it wasn't going to be helpful, but like Max said, they were really strong on that. And, it took to go into that courtroom. It was rough for me. Like I did not, it's not the way that it's supposed to be. You should never feel that way about going into a courtroom. Yet I did. And, but in the end, you just got to like push all that aside and say, I know how to lawyer. I know how to try a case. And I can even try a case with this judge who, some people would say doesn't like me. And so just focus on that. Focus on what the skills that you have developed over the years, and try to get the other stuff out of the way, out of your brain. And so that's kind of what we did. And so in the end, we pretty much did what we normally do, the brainstorming. Max set this up on a tee, like I've said before, and he was dealing with the 48 hours people the whole way. And I thought, boy, this would be great. I'm on Dateline in February in losing a case, and I've got a human being there, Rick Allen, that I have to worry about. But then you also have a business. I mean, you're not a human being if you're not worried about your business too. Right. And we lose that, and that's on Dateline. And then we'll go in, and 48 Hours has been following this case, and we lose that. And it's like, let's pack up the bags and split up the firm and move on, because this is not good optics. Yeah. So these are real life things that you worry about outside of your client. Of course, we worry about our client and love Rick and love Alison. So anyway, yeah.
So let's get into the kind of the concept, which is always an interesting thing in terms of having either a Dateline and or a 48 Hours or any kind of those magazine shows following and covering a trial. It's an interesting dynamic. Alison and I had Dateline, and I had negotiated that it was going to be the first ever 2-hour Dateline when they were going to cover the Garcia case out in Omaha. And, kind of one of the things that I agreed to, which it's important to me as a defense attorney and for the furtherance of our profession in terms of educating the public on what it is that we really do, that I wanted people to kind of see behind the curtain, to see what we do in terms of prepping for a case like that. So I granted them some limited kind of war room access, like where we'd have all the lawyers in there, and sometimes we'd have an expert in there, and we allowed them just to kind of be a fly on the wall while we were doing our work, just to give people an idea of what it's really like to kind of try a case like that. So when you guys are talking with 48 Hours, I mean, what do you guys end up in terms of access? What do you end up giving them, or what did they ask for?
Well, so we were kind of in contact with them throughout the case, largely because when the Garmin stuff, when it became clear what the state was going to try to do with it, I thought, if we lose this case, people need to know what's happened here, and it could be beneficial to have some media attention. And so they were interested from day one, but we kind of stoked the fire a little bit more once the Garmin stuff was going south, just to have that, as our insurance policy and to help with a potential appeal. We didn't, we didn't talk to him a whole lot before trial. I know, right? Well, we were walking around during deliberations. They kind of globbed onto us as they do and started firing some questions at us. And so they've got some very candid answers when we're, pulling our hair out, waiting for the verdict, that I'm wondering if that made it into the show, because I'd be very interested to see that. And then the crazy thing is, so then after the not guilty, the jail's like a block or two away. So we walk from court to the jail to start waiting for Alison to be released. And so they were standing around for that with the family members and us, just finally, taking a deep breath for the first time in a week. And that there's some candid moments there as well. I'm also interested to see if that'll make it on.
Yeah, and it's interesting because when you have one of those shows that kind of follows a trial, and if they've been there kind of from the onset, and they're aware of everything that's happening pre-trial and the ups and the downs, and if you do grant some interviews, and even if it's limited in terms of what you're saying to them pre-trial, it really depends on whether or not you win or lose the case in terms of how that episode's going to turn out, because context is everything. So, after the Dateline thing where I had given them a lot of inner sanctum access and we ended up losing that case, they then turned it around and edited it in such a way that we look like total douchebags. You know what I mean? Where they're taking like clips of Alison where the context of what she's saying is completely different than the way that they portray it in the episode. So the one thing that I feel very confident about in terms of the result that you guys were able to get for your client is you're not going to have to worry about that.
Yeah.
That they're going to be framing you guys in a very positive light because you got a very positive result for your client. So I'm excited about it. When does that thing air?
Saturday night.
Yeah.
Saturday night's all right for fighting. All right.
Saturday night at 10. And the Peter Van Zandt is the talent that he's been there for 27 years. He was a super nice guy. He told us, he said in all of his years of doing this, he's only had 2, including ours, but it's either 2 or 3.
I think ours was
the second one, not guilties.
They're rare, man.
Yeah, we're super rare. And he was very excited. And I also wanted to say that it's called, what's it called, Max? The
Death in the Stairwell, I believe.
Death in the Stairwell. And then there's the famous staircase. And I had talked earlier when I first got on that when I was at the NACDL, which is the Criminal Defense Lawyer, the National Convention, I ran into David Rudolph. And for those who know the staircase, which is kind of that might be considered the first true crime documentary, or one of the best ever done. And I just looked at him. I'm like, "Are you David Rudolph?" And he said, "Yeah, I am." And I said, "I just won a case involving or I told him I had a case involving a staircase death." And he said, "Did you win or lose?" And I said, "We won, not guilty." And he said, "Well, then you're a better lawyer than I am." And I said, "Well, you won that." And he said, "We lost the first one. Nobody remembers that. We lost the first one, and then we won the second one." And my client languished in prison for he knew the date, the amount of years. And I just thought that was so interesting. And he was the most humble guy, and he was super interested in, well, tell me about your case and how did you win? And did you have experts? And he's a real trial lawyer. That's why, because he was super curious about how did you win? He didn't really want to talk about himself. And I said, tell me about we have CBS. In fact, I need to text him because he told me, let me know when that's airing. I want to watch it. But he gave me kind of the inside baseball about how the crew from France that followed them around, how they got involved and all of that. And he's just a great guy. And I just thought it was interesting that David Rudolph, I ran into him. And so hopefully somebody will tell him that knows him that we mentioned him, because he's just a humble guy. And it was an honor really to meet him.
It really was one of the best documentaries I've ever. I think I've watched it 3 times.
If you haven't seen it, you've got to watch it.
Unbelievable. And it's got that thing because it's like, it's defense sided, and and David like really gave kind of that unfettered access, you know.
Yes.
So you see this case play out really from the beginning all the way through the process. It's an amazing documentary, and I'd love to have him on this show. So you text him and tell him I'd love to have him on at some point, because
I will do that. I mean, I have his number, but I don't want to act like I'm a great friend of his. He's just that type of guy. He was like, hey, I want to know when that comes out.
Yeah.
And
you don't have to be a great friend to just say, hey, this guy that has this YouTube channel for defense attorneys wants to have you on. That'll be it. That's it, Andrew. It's a small ask.
Oh, I'm definitely going to ask and let him know, because, you know, guys like him, and I don't know what he might be 70 years old. I don't know. He looks great.
Yeah.
But when they retire, and I don't think he's anywhere close to retiring, but all that stuff they have put up there in their brain, that goes with them. And so I like to hear these people come out and talk to guys like you and share information, because it helps all of us out. So.
It really does. And that was an unbelievable case. So how is Alison doing? You know, it's that thing where I don't know if people really can contemplate the amount of stress that our defendants, our clients go through, not just at trial, but every second from the time that they're arrested, leading up to trial, and then through trial, and then sitting in that fugue state in between closing arguments and when they go back to deliberate, and just waiting. You know, like how is she doing? How is she reacclimating to life, you know, normally, if she can? It's a hard thing to do.
Yeah, no doubt about it. I think she's doing all right. We've seen her. Andy saw her in person. I saw her on a video call, and I think she's bouncing back. The trial just took its toll to an extreme extent. I mean, she just looked aged, and she, we were concerned that the jury was going to look at her and, just by how beaten down she was by the process, and kind of hold that against her. And her hair had gone gray. She was in rough shape, but she's doing better. So that's definitely good to see.
Yeah, that's good to see.
Well, people need to remember that this was an accidental death of her husband, and she never really had time to grieve. She knew that at some point in time, soon after he died, that she was being investigated. And what do you do with that? I mean, there's nothing to do other than just sit there and wait and wait and wait. And then she's then in jail for 14 months, 15, 16 months, however long it was. And then you have to worry about the rest of your life. And so then she's out, and he really was the love of her life. He really was. And she's super sad about it. And she's got to, just like any spouse that has their spouse die, no matter how it happens, she's got to move on with her life. And by the way, Google her name and see that she was arrested for murder. How's that? And she should have never been arrested for murder. They should have gotten that Garmin data and figured out what that is, and then said, we're not going to file this charge. That's what should have happened, but that's not what happened. So
the old rush to judgment, tunnel vision forms immediately. And it's like, and I had Amanda Knox on the show like 3 weeks, a month ago, who obviously went through it, and ultimately she was exonerated, and that happened in an entirely different country.
Yeah.
If you can imagine the terror of that particular situation. And, one of the things, and like, she's got this new book out, and it's so thoughtful and thought provoking in terms of her talking about just trying to reintegrate into society, but still with the reality that even though you guys were able to get a not guilty verdict, that there's still going to be people out there that, because she was arrested, because the state says it so, are still going to think that she did this. And that's her reality moving forward for the end of time. I mean, she's never going to have to deal with the thought of that she's going to ever go back to prison on it, but she's going to always have to deal with the fact that maybe even her husband's family still thinks that she's somehow responsible for, you know what I mean? So that's just such a hard thing for people to kind of grasp onto and understand, that that's now her reality on top of everything else, trying to grieve for the husband that she wasn't allowed to grieve for, and trying to get back into a life where, you know, when she goes and gets a new job, everybody's going to be snickering about, oh, like, yeah, that she's the one who was, you know, it's just, it changes the arc of your life in such a profound way, man, that it's really just a lot to handle. And I'm always curious as to, that's why I asked you last time you were on. I would always love to have her on. You know, it's a safe space here. And, you know, it's one of those things where, you know, those stories need to get out more, because it's important for people to understand that when somebody is tried wrongfully, that is wrongfully arrested, and you're able to prevail, you know, by the will of God and great lawyering, and get out of that courtroom on the rare not guilty, that, you know, there's a life that exists for that person beyond that. And it's not easy. You know, it's not like you get a not guilty and you walk out and you're, woo!
Yeah.
You know, it's not that thing.
Yeah,
You know,
the 48-hour cameras were there when we walked outside, and I'm sure that'll be part of what's aired.
100%.
Yeah, but hey, one thing I wanted to also say is that this is a little get for you, okay? I don't think people know this, but there's still activity going on in Alison Davis's case, and which might cause Max and I to end up back up in Judge Gull's court.
What?
In fact,
Tell me more. The
Court of Appeals just ordered Judge Gull to have a hearing related to what we said was improper sealing of records. Max, you can go ahead and,
tell me, Max.
Yeah.
Sure. So they, right after the acquittal, right after the verdict, I think it was the Monday following the verdict that we got on Friday, the state filed this motion to try to seal everything that was completely illegal. I mean, they didn't even really try to put forth a legal basis. And then Judge Gull granted it shortly after, in full. And so then we filed a motion to correct error, in part because people need to know about what happened. And this was clearly, in our opinion, the state trying to stifle media attention. And so Judge Gull denied that. And so we appealed it. This is after she's been acquitted. We're appealing this illegal order that Judge Gull issued.
We did it for free and paid the filing fee. That's how
I love it.
Max was very convicted about it, and so was I, but not as much as he was.
I love it. Well done, gentlemen. Well done. Yeah, I mean, she's big on trying things in the dark.
Well,
you know? And
listen, just like the AG in Richard Allen's case agreed in the motion that you reviewed earlier, like, hey, I agree with Stacy and Mark that we need give them what they're asking for. That's what happened here. Go ahead, Max. Tell them. I mean, it's super.
So we filed our brief, and then the AG wouldn't defend the state's position. The AG said they're right. Basically, this was done without a hearing, which is clearly required by law, and so we'll just ask that it be remanded to the trial court. We're not going to argue for their position.
Yeah.
So it's been sent back to the trial court, and so.
Wow.
In order for a hearing.
When's that going down? When's that little?
You may want to come out there for that one, Bob.
I might want to come out there for that. Definitely. That would be a great joy for me to be able to sit in the courtroom and watch her eat gull. Oh, I mean crow. But that to me, it's a really important thing that you did. Because she has. I'm telling you, I just got today in my Twitter DMs a man that was just convicted in front of her, a guy, I think his name's Michael Allen, who apparently just more of the same that went on. And this woman is like, she sent me just a treasure trove of information about this guy's case. And I guess this just went down in front of her recently, another murder case, and another conviction, and just more of what Gull does in terms of denial of certain evidence getting in, and just keeping everything in the dark. And it's like, I think it's important. I like, if you guys let me know when it is, I'll definitely make it out there. I really
Yeah,
will.
we'll see if it ends up happening. But yeah, just to highlight again, this was the Attorney General who was going to write the brief for, the prosecutor's position, that the judge did what the judge did was inappropriate. The Attorney General couldn't even come up with an argument and basically said the judge was wrong. And the Court of Appeals didn't even get a brief or anything. The Court of Appeals just granted the motion, and the Attorney General, bowed out and said, get it back down to the trial court and have the judge do it the right way this time. And that's why there's going to be a hearing. So, that's I think that's a pretty rare thing. Maybe Osbrook would say something different, but I think it's pretty rare that the AG just says, yeah, we agree with the defense on this one.
He probably will. He's a real contrarian. I love that about him, though. Like, he almost always disagrees with me. So, but yeah, no, I'd really like, I mean, obviously the one thing that she can do is just unseal everything and not have to have kind of that moment where she's going to have to kind of, do an about face on her own ruling. So there's that, but I hope she doesn't. I hope that for whatever reason, she decides to allow the sides to litigate it. So then I can take a field trip up to Allen County and enjoy Max giving her the business.
I will be very nice as I am. I pray in the morning for everybody involved in all these cases, not every morning, but most mornings. And, because I want everybody to have wisdom, lawyers, prosecutors, judges, jurors, everybody. And so I say that very sincerely. I really do. It's not every day, but on many days I do. And it's easy to sit here and relish going back up and going in front of her. And part of you as a human being likes the thought of doing that. But the other part of you is I don't like it. I would prefer that it just gets done right the first time, and that there's congeniality among the people and all that kind of thing. So it's kind of a mixed bag for me, but I'm not going to not go up there. Okay. I will not go up there. I will be up there if there is a hearing. There is no question about that. So, yeah, I mean, you can't let the terrorists win. I mean, obviously I'm not saying Judge Gull's a terrorist, but there's a parallel, I mean, in terms of her kind of like pushing you around, you can't let her win, Andy. You got to be able to, you're a storied attorney. You've been doing this an awful long time, and you have every damn right to walk into that courtroom. So, plus I hate to tell you, it's going to be very fulfilling for you personally. Quietly inside, you'll be feeling very happy. Maybe I'll say Max was the one pushing this, though. I was ready to be done with it. And Max is like, no, she can't continue. This was wrong. She can't. That's what he said. Max is one of the good guys, man.
Yeah. I recall Andy being a little bit more supportive of the appeal.
I mean, as soon as you brought up the concept, Andy was all about it. He's like, "Oh man, that sounds like a great idea. Hey, have you finished that thing yet? The thing we were talking about."
Hey, by the way, an intern. We had an intern draft that. Matt,
Matt Vernon. Yeah,
Matt Vernon.
Credit.
He drafted it. Yeah, he did a great job on that. So I want to
well done, young Matt. Love it,
Matt Vernon.
No, we got one coming up, man. It's always good. Got to keep those young defense attorneys, like our future defense attorneys coming up through the thing. It's like, and it's, I'm making a little bit of light of it, but I'm very passionate about transparency in the courts, because exactly what you were saying, Max, it's critical. I mean, it's really all we have. I mean, it's the only way that we can hold the government accountable. So, frankly, it's a big deal. It really is. And I'd love to see judges like that, because, you get a judge that kind of gets hammered like that, and she has to undo what she's done, especially when it's dealing with something like sealing records, which are public. These are public trials for a reason. That sets an example for other judges that may be inclined to do that kind of thing. And, and I was reminded of, the judge in the Koberger case, because and it really started with Rick's case, where I started to see this trend of the prosecutors wanting to seal all the documents, starting with probable cause affidavits for no good reason. You know, I mean, they have to have, it's got to be extraordinary circumstances for them to be able to say, you know what, we can't have this go out to the public. We're worried that it's either going to destroy the investigation and other possible suspects, or it's going, you know, possibly a witness is going to be harmed, whatever the case may be. Like those types of situations have to exist. But you started to see this trend. And then when filings are happening, they're wanting everything sealed. That's not the way this thing works, you know, and I think what the problem that we're seeing, it's the counterplay with this, with what I do. It's the social media, the YouTube, the fact that people are now interested in pretrial hearings, where if you think 7-8 years ago, when you were to turn on court TV, you'd never see a pretrial hearing. Now they're commonplace. And I love that. I love people being able to watch every part of the process, because like I tell people all the time, the real wars are fought in the pretrial motions that are fought, because that's what's going to ultimately determine what makes it in a trial and what doesn't in terms of evidence. And that's, you know, when you're watching the trial, you're watching the, you know, the final battle when the real war took place beforehand. Mm-hmm. So yeah, I'm all about it, man. And I'm dead serious. If you guys get the opportunity to get in front of there and Max gets to argue it, I'd love for you to give me a heads up, so I could make a trip up there.
Yeah. Will do.
Sure. For sure. All right, you guys promote your amazing law firm. I've been throwing the Twitter, and Max, I don't know if you know, Andy apparently had no clue. You guys have a nice little Twitter account going. I saw it for the first time today. I'm like, oh, look, Andy's firm has a Twitter account. You guys had some stuff up there promoting some of the business.
We've been working on it.
Things. It's good. It's good. So what's the handle for your Twitter account, or X? You guys know what it is? Andy doesn't know what it is.
No, I don't either.
Oh, good God.
I'm sorry.
Criminal defense.
You two guys.
There's an underscore.
Kathy Perry. She's been pushing that.
Yeah, there's an underscore there.
She's cursing our names right now.
Yeah, exactly. You got somebody that's working really hard trying to build up that X profile. All right, hold on. I'm gonna pull it up again. And I think my there it is. All right, thank you, Tracy. So everybody go follow Andy's firm, and it's crim_defense_team. Give them support. They're wonderful attorneys. They're out there fighting the good fight every day for their clients. And you know, if you run into a little trouble in Indiana, these are the guys to call. I know who I'm calling. So
well, we didn't get Mark Sanchez, but you know.
Yeah, it's funny that you brought that up. I'm doing a Mark Sanchez live, and immediately I'm like, I hope they call Andy's firm. I'll have an in. And and I've got another buddy named Chris Askew. I was like, those were the two guys. I was like, I hope that they hire one of those two guys, because I'm buddies with both of them. But yeah, that's an interesting case, man. I think I immediately thought CTE. You know, that, like, I just think that's the thing with. You know, I'm sure he was in talk, because everybody's like, no, he was drunk. I'm like, okay, they're not mutually exclusive things. This guy's played football since he was a kid and played through college, and then had a long career in the pros, and he got his head smashed in a million times. I have no doubt. And the problem with CTE is they can't find out until it's post-mortem, you know? So, but it seems to have the earmarks of it, because it's like, it's a weird thing for him to have popped off like that. And ultimately he was the one who took the brunt of the damage. So it's an interesting case. It's going to pull some media into your fair city there. That's
maybe sure. if the 48 hours had aired before this, then he might have.
Timing is everything.
So, timing is everything. But he's in good hands with a good lawyer here in the city. So
indeed,
indeed.
All right, gents, you have any final thoughts? Any final statements before I boot you off here?
No. I don't. I'll just say thank you to everybody that's out there that supports Richard Allen, and I can't get to every single email and that is sent my way, and I try my best, but keep sending it, please, because what I'm doing is when I do get a chance, I then send it to an e-file in my office, and so that because like what you said, Bob, I made that promise, and I'm keeping that commitment and that promise. If it gets reversed, and if I am back on the case, there are going to be people out there that are going to be involved in this, and we're just going to have to figure out how to make it work. We're going to have to figure out, are we going to rent some hotel space somewhere, and everybody flies in from wherever they're at, and we all brainstorm together and come up with ideas together? That would be amazing to me if we could do that. It would be unbelievable And because you don't have to be a lawyer to brainstorm and to come up with great ideas. And the people that watch this show, they've come up with amazing ideas, but just have some grace for me because it is hard. I have a law practice, you know, I had a trial a couple weeks ago and, you know, and I've got another one coming up in November. It's just, these are hard. The trial law is hard. And then in the background, I've got Richard Allen and everybody that is so passionate about it. And I'm doing the best that I can is all I can tell you, but you will be involved at some point in time. Okay. That's
there
what
you go. Heard it straight from, I mean, you know, I mean, look, fresh eyes, man. Like there's nary a situation where I could think that 50 brains isn't better than one, you know?
Yeah,
so
absolutely.
That's just kind of how I feel about it.
I'm laughing because we had an inside joke with me and Max on the Alison Davis case about with the term fresh eyes. So I'll just, that's why I was laughing at when you said the fresh eyes, but yeah, fresh eyes matter. And anyway, thank you, Bob.
Absolutely.
Thanks for having us on.
Always. You guys always have a home here. I told you that last time and it stands. So thank you, gentlemen. Great work on Alison Davis. We're all keeping our fingers crossed on Richard, and I hope that thing ends up coming back. And we're doing all again. It's awful for the families, but it's a cautionary tale. You gotta watch what these judges are doing in these things. And
Chelsea, I'm looking at your thing there. As much as I'm able to see, and it's thousands and thousands and thousands of emails and calls. Seriously, thousands and thousands, and weeding those through that is difficult. So
it's a challenge.
Yeah.
And then Gen X lawyer said, Mr. Baldwin, thank you to you and Mr. Rosie for representing Rick Allen and doing so in the most ethical manner. What an immense task. You know, you always get the love over here, Andy.
Yeah.
Brit happens. I'm just going to read you guys a few of these things. Love and support to you, Andy and Rick, and prayers that the truth is very soon revealed. And, you know, it goes on. And that's the white car question. Here's speculation. What happens if Mullen had them? They're lost forever. Talking about the exhibits. And, you know, I was propping you up, but I can tell you definitively that Andy absolutely ripped into Mullins when he was chuckling on the stand about losing evidence. So I know for a fact that you can get in somebody's ass if they need it.
That was funny, Tammy. Thank you.
And then could Andy give the appellate lawyers? So we asked that. Dr. Von Kay, who's a ride or die, thank you so much from us all. And let's see what else we got. Here's a longer one. Can we get Rick's new address? I wrote him several months ago, but not have heard back yet. I wanted to chat with a fellow Hoosier who's so very innocent and give him some support until he's freed. And that's free Rick Allen.
I don't know the address of where he's in Red. It's somewhere in Oklahoma. And I'm sorry, I just don't know that.
If you figure out what prison he's in and you just let me know, I'll post it so that people can try to figure out how to, you know, because if you go to the site for the prison, they'll tell you how to mail things to certain inmates and things like that. So and then Bailey, free Ricky, horrible case of injustice, but it brought me to DD, which I will forever be grateful for, as am I. Thank you. All right, so you guys, thank you very much for spending your valuable time with me this evening. Everybody make sure to tune in on Saturday, 10 p.m. Eastern, 48 hours. Watch these two guys in action. Watch them bring home one of the rare not guilties. It's hard to beat the government. It is hard to beat the government. So well done, gentlemen, and keep fighting the good fight, yeah?
Thank you.
Thanks so much,
everybody.
All right, you guys. Bye. All right, so that's it. I'm going to go through the rest of these supers. Idiot Win, thank you so much, as always, for 20 gifted DD podcast memberships. That is so very generous. What a wonderful dono. Love it. Stephanie, Canadian. That's Canadian. $7 solid Canadian tuning in from Montreal. I love our Canadian neighbors so very, very much. Makes me miss Runkle. I miss Runkle. I got to get Runkle back over here. It's been a hot minute. Who's your girl? My favorite trio. It's always great to have Andy on with us. And Max. I love Max is a little shy. You can tell Max isn't like quite used to being on the tubes yet. Andy was a little reticent at first too, but he's taken to it. He's taken to it. So which is good to see. So thank you very much, Who's Your Girl, for your consistent 14 months of support. That's amazing. Bailey, Caroline, family hug. Thank you so much. We appreciate you becoming members. Kraken, 18 months. OG, I know. I hope Rick knows he has massive support. I hope he does too. I hope he does too. It's important. I mean, that's a lifeline to these people that are incarcerated, and especially if it's a case where they're wrongfully incarcerated and it feels like there's no hope and you're wondering if anybody cares. Yeah, it's big. It's big for them to know that. So, you know, I always let Kathy know. And I think Kathy makes Rick aware, obviously, that there's a lot of love for him out there and people are thinking about him a lot. So I think that message is making its way to Rick. Bailey, after becoming a member, then donos $5. Free Ricky, horrible case of injustice. But it brought me to DD, which we're so grateful for. We're so grateful that you guys hang. And then Stephanie, mom, member for 1 month. Oh, family hug. Hi from Coal City, Illinois, an hour from Chicago. I know where it is. Driven down past there many times. So welcome and thank you for being a member, Stephanie. We appreciate that. Classic overthinker, member for 5 months. Did the defense speak to the group of 3 girls? Damn it, I wish I would have seen that. He's not going to get into any of that kind of stuff because that is all any kind of post-conviction stuff. Andy's just not going to talk about. Like, he just won't, and he may not even frankly be aware Osbrook's the one we should be asking about that. But you know, I don't know if the attorneys like, because that thing drives me nuts. I was just texting about it today. Some dude was cracking back on some shit, and like somebody put up something about how Rick Allen had seen 3 girls and it was 3 girls that saw Rick Allen. I'm like, no, wrong. It was 4 girls. And whoever Rick saw was, I'm assuming, a different group of girls, not those 4 girls, because none of those girls described anybody that even sounded remotely like. When somebody doesn't call Rick short, the first thing when you're describing him, they're full of shit. They didn't see Rick Allen. I'll die on that hill. Ariel, can I have the Frank's exhibits? And please and thank you. And please and thank you, Andy. Yeah, I mean, I'd like to get them all too, frankly. Dr. Vonda, we love you so much. Thank you for your continued generosity. We just adore you over here. Lara or Lara? It's one of those 3 has to be right. Can you give Andy, the appellate lawyers, your copy of the, so we asked that. We got that. Thank you very much for your generosity. Tammy, I got that up there. Made Andy chuckle. That was a big win. Boogs, I tried, you know, got shut down. Did the best I could. Debbie Olds, new member. Oh, family hug. Welcome. Britt Happens. As always, we adore you. Thank you so much. Love and support to you, Andy and Rick. Yeah, I was able to read that one. Gen X, thank you so much always for your support. Got that one read. True Crime with Eve. I've been curious about what other photos were taken by the bridge that day. McCain, me too. Like, that guy took a lot of photographs. Seems like you would have caught some shit in the background, right? I'd love to see those too myself. True Crime with Eve, 100%. That's a damn good question. DSN member for 3 months. Thanks for the membership. I'm assuming you got one of the gifted, so that's fabulous. Welcome. Chelsea, could you ask Andy how many? Oh, saw that one. Keith, got you up there. Thank you both for your generosity. Nick Stero, always love to see you in here, brother. You're another guy. We need to hang soon. Hit me up. Let's hang. Doctor, and thank you for your generosity, Nick. We appreciate it. Dr. Vonda K gifted another 10 DD memberships. Appreciate that always. Yes, I agree. I mean, there's no other way to look at it, really. I mean, to me. But thank you again, Tammy. Appreciate it. Thank you for the double feature. Sky, thank you for your generosity. Jess, thank you. Max, for sharing your insights. I wish I would have thrown that up. Hopefully you saw it. I threw it up, but I didn't read it. Oh, Pammy, look at that. Talk about OG, 20 months. Love you, Bob and Allie. Love you back, Pammy. Love you more. Thank you so much for all your support always. Fids, I'm in Indiana and bald. In is a badass and such an amazing man. Oh, Andy Baldwin. I see what you're doing there, Fids. Thanks for always having him here. Free Rick Allen and pray for his family. Thank you for your generosity. And then finally, Where'd it go? What happened? Oh, there it is. Aw, family hug. Welcome, 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 Chris and April Martin. I'm assuming that's two of you. Maybe it's one. I don't know. Who knows? All right, you guys. Look, tomorrow, I think I'm going to have Lauren Conlon on. We're going to be covering the Mark Sanchez case, which Andy got into a little bit. I'm excited to cover it tomorrow. We're going to get into it. I saw that Michael and Linda actually had a live on Sanchez today. I'm wondering if they saw my posts, because I was on that CTE shit immediately. Like, and I had some people like, oh, no, I was drunk. I'm a bartender. They don't have to be one or the other. He can have CTE teeming through his mind. Look it up. See what it is. People that get hit in the head repeatedly by 300-pound men wearing a helmet, it is going to rock your brain against your skull. And when you do it repeatedly, there's shocking statistics that almost every single NFL player that they have donated their brain to look at has been riddled with CTE, and it causes rage and it causes all kinds of issues, which when you combine it with alcohol, I just won't be surprised at all that like he's got CTE. And the problem is you can't diagnose it until post-mortem after death. But I think, and Allie and I were talking about it, I think you can get an expert on there. I think that you can get doctors in there to come in and talk about it in terms of mitigating the damages. And, you can have people on. Huh? Dinner's ready. Oh, my wife who dipped on me just came to tell me dinner's ready. So what that means. Mata out. But I think we're going live to my time. Oh, and I got a couple of Venmos. I want to shout them out. I got one yesterday that I did not give the love on, so I want to make sure. Tracy always tells me, Bob, check the Venmos. So let me real quick, take a peek at these guys here. Tonight, Leslie, thank you so much for your $10 Venmo. And then yesterday, Lisa, thank you very much for your $5 Venmo. We always appreciate Venmos because the tubes doesn't get a cut. So always love those guys. Those are always our favorite. So, all right, you guys. So again, Lauren Conlon, me and Allie talking Mark Sanchez. We'll go through whatever's out there document wise. We'll see if there's any interesting clips out there. And we're going to read the civil complaint that was filed very quickly. Very quick turnaround on that. Mods, thank you very, very much. We adore you. We thank you. We cherish you. Tracy and Mandy, I don't even know if Mandy's in here, but Tracy, I know you are, as always. We adore you. Thank you for everything you do. Tracy always gives me everything I always need on a daily basis. You're just an amazing human being. And Tracy, we love you. Oh, and Allie just yelled up, Sleuthy, we got to give you the love too, because you're samies. Anytime we need a document that I know from Richard Allen or a case that I know that you're deep into, you immediately hit us with it, and we just love you to death. You're an amazing human being. So I hope I gave enough love to the cranks today, to Andy, and I hope that I guaranteed that y'all are going to be well used should our boy get a new trial, which we're all hoping will happen, because it needs to happen. And we got to have y'all doing the amazing things that you do to help those guys out. So, all right, y'all, thank you so much. And just remember, without you, I am literally just an old man talking about a whole bunch of cases. See you tomorrow.
Alison.